Good afternoon, folks, and welcome to the Legal Beagle Podcast. We are back after a 4-week break. And the reason for that break is the very topic that we're going to discuss in this week's podcast, and that's trial work. Our firm found ourselves in trial at the end of April, and so the entire month was prep work and getting ready for that trial that took place. It was a 4-day trial at the end of April. Here's what I'll tell you. It's good to be back in trial. It's been a minute since we were there, and we have shifted the focus at our firm to be more trial-based work. And sometimes you have to go to trial. Sometimes there's just no way to resolve a case without going to trial. I'll tell you my 3 takeaways. 1, trials are hard, and we'll talk more about that. 2, trials are unpredictable, and I'll share some experiences with you. And 3, trials are where you find justice. And I really do believe that because there are times where you can receive some sort of justice, which is really essentially accountability for the wrongdoing by the defendants. But there are times where you can find that in settlement, and we often do. And there are a lot of reasons to resolve a case through settlement. But I will tell you that I don't think you get the fair amount of justice that you truly deserve unless you take a case to trial. And it doesn't mean that every case needs to go to trial, but unless the defendants, and really I'm talking about insurance companies, know that you're serious, they're not going to take you serious, which means they're not going to take your client seriously. So let's start back at the beginning. This case took a few years to get to trial, and that's often the situation. And the reason I bring that up is because clients ask us that a lot. They say, how long is this whole process going to take? I used to say 12 to 18 months. That was an aggressive timeline that is nowhere real in what we're seeing today. And it doesn't have so much to do with the pandemic and the courts being shut down for a while. It really has more to do with just the time it takes to get these cases ready for trial. And to be fair, there's work to be done on both sides of the aisle, right? From the plaintiff side to the defense side. And there's depositions that need to be taken. Medical exams may need to be conducted. Just getting medical records and getting everything in place from the experts might take a while in order to get a case to trial. And then, of course, you're at the purview of the court and the people that are determining this case. Or your case. There are 2 different types of trials. There are bench trials and there are jury trials. Bench trials are where a judge hears it and then makes the decision. A jury trial is what you would probably know from the TV and movies that you've watched. It's a jury of your peers. They're selected, and then they deliberate and make a decision on the case. This was a bench trial. And let's start with the first point. Trials are hard. Trials are hard, and they are. They're hard on everyone, not just the attorneys involved or the clients involved. They're hard on the judicial system. They're hard on the people that are making the decision in the case, whether that's a judge or a jury. They're hard on the experts that are involved or the support staff at the firms. They're just hard. It's a mountain of work, and there's no way to really capture that in words. You just have to live and experience it. And frankly, I would hope that most clients don't have to live through that, because it's not a fun experience for most people. Look, you're in trial in a personal injury context because you were hurt in some way. You're not in trial because trial ends up being some sort of positive experience in the way that you would think it would be. You're there because of something that happened that impacted your life, that disrupted your life, that then caused the need for the claim that you brought, which eventually a lawsuit was filed, litigation ensued, and then you ended up in the courtroom. That's not, this is what we do, right? And when I say that I enjoy the work and I really have a sense of fulfillment that comes along with this work, that's because this is what I've signed up to do. People that are driving down the road and get hit unexpectedly in a car crash, they weren't looking for that. They weren't expecting that. And so I acknowledge that and I recognize that. That's why trials are hard. They're hard on everyone. There's stress involved. Look, the prep work to go into a trial, uh, the one that we did was pretty extensive. There's weeks and weeks and weeks of prep, rereading deposition transcripts, talking to your experts, thinking about trial strategy, working on the opening statement, working on the case in chief, which is where the plaintiff puts on their witnesses, then working on rebuttal uh, for the defense case in chief that they put on to essentially argue against the plaintiff case. And then there's your closing argument at the end. And that just takes time and it takes a lot of work. The testimony of witnesses can be extensive. You may have taken this witness by deposition earlier in the case, and then you've got to take them live, and you basically have to redo everything you did in the deposition. That holds true for the plaintiff oftentimes. The plaintiff is going to be asked to sit through a deposition at some point during litigation, and then they're going to be asked to be taken live at the time of trial. So they're going to ask or be asked a lot of the same questions that they were asked at the deposition. The problem is the crash may happen on one date, the deposition would happen on some date after that, and then the trial would happen on some later date after that. And so there's changes that are occurring with the plaintiff along the way. They may be getting better, they may be getting worse from their injuries. And so there's this evolution that happens during a case that is where I say real life intersects with the law. And that's just that, the law is not, it's not black and white, and it's certainly not, you can't put people in boxes or cases in boxes and categories. It's this fluid transitional thing that happens, as you're experiencing it. And that's what makes it exciting for me, but it also makes it very difficult for people who like a lot of structure, because you're not going to get a lot of that when it comes to trials. The stress is real. The stress on everybody is real. The trial itself was 4 days, and it was. There's a line from Jerry Maguire that I love. It's an up at dawn, pride swallowing siege to do that work. We were up early mornings, very late at night, very little sleep. Your family and friends get pushed aside because you just don't have the ability to focus on anything but the trial itself. In fact, when this occurred, my wife had her birthday, and she knew that her birthday was falling in the middle of this trial. And I was able to peel away for dinner, and we had some friends over and some family, and I was able to share a few moments with them, and then I went back to work. And that's just the reality. And we were able to celebrate more fully after the trial. But I share that with you because it's the real dynamics of life and what happens with trials. The plaintiff, every day we're talking about what happened that day and giving updates and talking through strategy and just trying to calm the nerves that are truly there for the person who's given their trust and faith to a third party, and said, that third party being a judge or a jury, and saying, you make the decision, because the parties can't simply agree, and we're asking you to make that. That brings me to my second point. Trials are unpredictable. Weird things can happen in trial, and our trial actually happened in a virtual format like this. And through these podcasts, I'm very comfortable talking into a little dot on my computer screen like I'm doing right now. And so it's not so uncomfortable for me, but for others who aren't comfortable with that, especially clients and experts who haven't done it, it's weird to have this conversation through a computer. Technical difficulties weren't really apparent. We got through that pretty smoothly. That really wasn't any issue. But people can change their testimony at trial. There was an expert who testified who just flat out lied on the stand. And we knew it. I suspect that expert knew it, but At the end of the day, all you can do is try to prove it through the prior testimony, through evidence in the case, and hope that the trier of fact, that's the judge or the jury, hears what you're saying and picks up on it and understands where those lies occurred. You have the chance at closing to argue that and explain it a little bit better. But as it's happening, it'll catch you off guard because you don't expect people to change and do an about face during trial. They usually stick to what they said because most people, I think, are trying to be honest, at least as they believe in their mind what is honest. And I say that because there are a lot of defense experts that will say whatever the defendants want them to say. And, we see these same reports over and over and the same findings over and over. Do I think those experts are intentionally lying? I don't know if they're intentionally lying. They just believe they're serving another master, and they believe that their service to that entity is more important than really being, what we consider fair and reasonable. And that's why you end up in trial. That brings me to my third point. Trials are where you find justice. Now, I talked a little bit about accountability, and I believe accountability is a byproduct of justice, right? That you go to court to try to resolve your case because you can't reach a fair resolution somewhere along the way. And just to be clear, we're talking about the civil justice system. There's this criminal justice system over here that operates kind of independent. Those are our two justice systems in this country, civil and criminal. Neither are less important or more important than the other. They have different ramifications, they have different consequences, but they aren't less important. One isn't less important because you're not taking away someone's freedom. One isn't more important because you are taking away someone's freedom. It just doesn't, that's not my belief. I believe that that our system was set up to be a justice system, and there's a civil context and the criminal context, but justice is justice. Justice is accountability for what happened. We've seen that in recent happenings in the news and just in society. The news is reporting what's happening, but just we've seen that, right? I mean, I think it was George Floyd's brother that said after that verdict that what they found was accountability through that verdict, the guilty verdict for the officer. And I think that's an interesting point because that's really what you're looking for. You're looking for some sort of accountability, right? To hold the wrongdoer, whether it's a criminal wrongdoer or civil wrongdoer, accountable for what happened. And that's why I think you find justice in the courtroom, because sometimes you can't find it outside of the courtroom. Sometimes you certainly can't find it if the opposing party, that would be the defendants, aren't going to be fair and aren't going to treat this situation seriously and aren't going to consider what happened in the particular case as a serious consequence of the defendant's actions. And so you sometimes have to get there. And so in doing that, you face a variety of obstacles. You face consistent denials, right? And I found this, and I actually use this in my closing argument, that in psychology, denial is really just a refusal to accept reality. And it's an interesting way to define the word denial, because that is essentially what I think you're getting when the defendants deny the claims, deny the injuries, deny that the accident or crash, caused the injuries. That's a refusal to accept reality. Because if you step away from it and you really look at it from a third party perspective, and that doesn't mean you have to go to focus groups or anything to get that, but you just ask everyday people and you put simple facts, I think people can agree on certain basic reality that surrounds the claim. But you get a lot of denials from the defense, and those denials are not based in any sort of reality, and those become exposed at trial, and that's a great time to do it. You also deal with unfair value. Unfair value is what the defendants think the claim is worth, as opposed to what the plaintiff thinks the claim is worth. And that's a disagreement, sure, but let's look at our judicial system and what the justice system says is value of a claim. It's the fair and reasonable amount that should be paid to make someone whole, to compensate someone for what injuries have occurred as a result of the crash or the injury. It can be in a slip and fall context. It could be in a medical malpractice case. It could be in a, with a dog bite. So it doesn't always have to be an auto crash, but it's in the injury context. Fair and reasonable, those are important words, because fair and reasonable does not mean discounted, and it does not mean cheap. It means fair and reasonable. Look, no one's winning any sort of award by going to trial. No one's winning any sort of contest by getting into litigation. No one's walking away wishing this would have happened again because of some sort of aftermath that is experienced as a result of a crash. There hasn't been one client in my entire time of practicing law, which is almost 10 years, there hasn't been one client that has ever said to me, I would go through this again. We've had some fantastic outcomes. We've had some trials. We've had some cases that went deep into litigation. We've had some just amazing experiences where we've really become almost like family members for the clients that we represent. But not one of them has ever said to me they would go through this again, meaning they would not give up their health and well-being, their physical health and their mental health for some sort of compensation, some sort of check that's going to be written by the defendants. And I think that's a perspective that people can appreciate now more than ever, having gone through 2020 and the pandemic and COVID, and understanding how really important our health and well-being is. It's not just physical health, it's mental health, right? People suffer from all sorts of things in all sorts of ways. And until you can go through that and live it and experience it, and you don't think that you're immune from all of it, and I think that leveling factor really was 2020 and the pandemic, because I think people realized for the first time, everyone had someone that was affected in some way, whether it was a friend, whether it was a family member. There was concern for parents. There was concern for people with pre-existing underlying medical issues. I think the overall sense in society, and that's humanity, right, was that, look, our health is more important than anything else. And I think that's a benefit to plaintiffs everywhere, because I think people can be reminded of that in subtle ways. And I think people can appreciate that better. Those people that will sit on juries coming out of what we just all experienced, and to an extent are still experiencing, I think will have a little bit of different compassion in their heart for what it means to be stripped of those things without your consent, certainly without your involvement. And maybe that's a bad word. You certainly get involved, but not because you chose to be involved. You didn't ask to be injured. I don't think anyone that I've ever represented asked to be injured. And so they are, and usually there's someone at fault for that injury, and that someone should be responsible and pay the injured party for what happened to them. And that's what forces these cases into litigation, which eventually find a courtroom. Although I will reaffirm what I said, that trials are no fun for everyone to a certain extent, there is a sense of purpose in getting into a trial and telling a story and having that story heard by others, and then having a resolution that is fair and reasonable, and allowing for closure in a way, because this is an open wound, the case and the injury that occurs, and it doesn't really ever get fully resolved until you find some closure in and through our judicial system, through the justice that our Constitution allows. And so that for me is very powerful. That sense of purpose, that sense of closure, that sense of support that we can offer. And I'm proud of the work that we do. I'm thankful for the clients that allow us and trust us to handle their cases and give us the freedom to do the work that we need to do to help them find that justice. So that has been where I was. I'm actually stepping into another trial in, it's just over a week. And so I will certainly update you about what happens with that trial. But that's what we're about. That's who we are. That's what we'll continue to be for those defense attorneys, for those insurance companies, for those defendants that may watch this. We're not going anywhere. And that's not just me speaking for me and the attorneys at my firm. That's all plaintiffs everywhere, and the attorneys that are thankful and prideful of the representation that they have. We're not going anywhere, and we'll continue to have these stories told in public forums so that people can be aware of what's really happening out there, and that the propaganda and the public spin isn't necessarily what's real and isn't necessarily what's occurring. So I'm thankful for you listening. I'm thankful for the people that I get to represent, and we'll be back with more episodes very soon. Thanks.